I know him when he was a lecturer at Shatavahana College. He invited me for a performance of Astavadhanam. I still remember in his college. We are friends from that day onwards, say around 70s. Then he has a very good academic career. He postgraduated from Andhra University, Visakhapatnam. Started his career with Shatavahana College, Vijayawada. Then he moved on to the residential college, Nagarjuna Sagar, where he was principal for a long period. He trained several students who became IAS and Group 1 officers. And they even still now, they respect him with great reverence. He was a principal Ananta IAS Academy also. He succeeded me. Then he was invited by the Lord Balaji, TTD, as Secretary Dharma Prachara Parishad. He was Director Sita Endowments. He trained several endowment executive officers up to the level of joint commissioners. Then he was Director Skill Development, which was a new innovation by government of Andhra Pradesh when it went to Amravati. He produced half a dozen IAS officers to his credit, and he is an authority on Valmiki Ramayana and an erudite scholar. I request Dr. Mr Raghavachari garu to kindly discuss about the center and state relations. Sir.
Sir, we would like to request you to unmute yourself, sir.
Raghavachari garu.
Unmute.
Yes, sir. Yes, sir.
That's fine. Okay. Namaskaram.
Namaskar.
Jai Shri Narayan. Jai Shri Ram. At the outset, I am profoundly grateful to Dr. R. Ananta Padmanabharao garu, who had been a great friend of mine, a proud privilege to be his follower and a friend for the last 45-50 years. And his wonderful career, starting from a faculty in Government College, Kandukur, top to Additional Director General, Prasara Bharatiya Doordarshan. His wonderful career ahead. It's nice that he had been organizing a kind of motivational or inspirational lectures for the IAS aspirants. I deem it a privilege to be a part of the wonderful program. Friends, I have been asked to speak on center-state relations. We call it simply federalism. The Indian federalism is a unique one. It is the word federation was actually derived from a Latin word foedus, which means a treaty or agreement between the federal government and the federating units. What is the state and agreement? Because federal system is a wonderful device, a wonderful political legal instrument, an excellent arrangement for the convenience of the central government and the state government, each working in its own domain. It is to reconcile the national unity on one hand with the elements of states' rights on the other, or giving autonomy, or what you call giving a kind of freedom to the state governments in their own sphere. And we have the United States of America, USA, as the classic or best example for a kind of federal state. It was started in 1789 and a wonderful federal state which had become a source of inspiration for subsequent political systems elsewhere across the globe. Canada in 1867 has become a federal state, followed by Switzerland and Australia in 1901. Switzerland is a kind of federation which we normally call a confederation. We'll try to discuss it later in course of our interaction. India is also a federal state, but our constitution has declared India in its first article. India is a union of states not a federation. Though we are a federal state, nowhere in the constitution the word federation can be found. This is a very wonderful thing. Similarly, we have followed a cabinet system of the British pattern, but nowhere in the constitution we have used the word cabinet. So there are certain features also. And our constitution had provided a very strong centralizing federal system. That means our central government is stronger for various reasons. Now, the second thing, on what factors contribute to a federal system? Unless we understand what is a federation, how the federalism can emerge, we cannot go into relations between central government and state governments. The basic conditionality is there should be a rigid and supreme constitution. This is only the dividing line. This is only a basic factor which divides the claims of the center and the states. At no point there shall be a conflict of interest. So constitution should be rigid, it should be written, and also supreme. The second thing, essential condition is there should be two sets of government. One, a central government, and two, the state governments. We call them federating units or provinces or states. And the most important thing is there should be a clear-cut, distinct division and distribution of powers between the central government and the state governments. This is a very important point. Right. Then, in case of any conflict of interest or over allocation of powers, there should be an independent and supreme judiciary. We had been experiencing for the last few months in India how the states are claiming certain things and they are refused. They are not given clearance by the supreme judiciary. Above supreme judiciary, there is nothing. In few cases, the president may take some liberty, but in this case, it's not like that. So, a supreme independent judiciary is another condition. Then, in case of amending the constitution, we call it a constituent power. This is a constituent power which implies the procedure of amendment of the constitution. It is shareable between central and the state governments. And then bicameral legislature. That means there should be two houses of parliament or union legislature. In India, we have an upper house of what you call Council of States, Rajya Sabha. It is then elected by the states. And there is a popular chamber, what we call House of the People, we call them Lok Sabha. So Lok Sabha being the lower chamber, Rajya Sabha being the upper chamber, these two chambers are essential in the federal system. In America, we know House of Senate and House of the People, Congress. Similarly, in some countries like United States, there is a provision for double citizenship. The central government gives one citizenship and the state government gives another citizenship. In India, we have only one citizenship, Indian citizenship. This is the basic framework of any federal system. Now, let us see the legislative relations in brief, because the focus is only administrative relations. But unless we know the legislative division, it's difficult to understand how the administrative relations have emerged. In terms of legislative relations between the central and the state governments, Article 245 to Article 255, they deal with these legislative powers. Indian Constitution is a federal in form, but people say, but it is unitary in spirit. So what for this has happened? To preserve the unity and integrity of the nation, this has been so clearly provided in the Constitution itself. Powers are divided between the federal government and the federating units or state governments in legislative, executive, and the financial spheres. However, there is no division of powers provided in the Constitution regarding in the judicial sphere. We have an integrated judiciary established by the Constitution itself to enforce both the union and the state laws in a respectable manner. So the division of powers occur in terms of legislative powers, executive powers, and financial powers. Judicial powers are not divided between center and the state governments. Constitution Part 11 discusses legislative powers and interrelations. Part 12 explains the financial relations between the federation, federating center and the units. What are these legislative powers? Article 245 to 255 deal with the legislative powers. Chapter 1, Part 11, Articles 245 to 255, they relate to the legislative powers of the central government and the state governments. For the purpose of convenient administration, the Constitution has provided 3 lists. One is list 1 called Union list, or the central list, or the federal list. It is the longest list. Presently, there are 100 subjects. The Union government has exclusive power of legislation over the items included in the Union list. For example, defense, foreign affairs, railways, war and peace, airways, national highways, shipping, post and telecom, currency, banking, UPSC, All India Services, Prasar Bharati, Padmanabharao had worked as a Assistant Director General, elections to Parliament, atomic energy, international treaties, citizenship, so on. There are 100 subjects like that. On these subjects, the central government can make laws anytime. The laws made by the Parliament on these subjects are equally applicable to all the states and also the citizens throughout the country, except otherwise stipulated. Then, the Parliament makes laws for the Union territories also. For example, Andaman and Nicobar Islands, Dadra Nagar Haveli, Chandigarh, Lakshadweep, Puducherry, the national capital, Delhi, Ladakh, Jammu and Kashmir. So there are other union territories. Some of these union territories enjoy a partial statehood. For example, Jammu and Kashmir, Delhi, and Puducherry, they have their own assemblies, they have got their own chief ministers. And recently, Daman and Diu is merged into Dadra and Nagar Haveli. Then states. We have some 29 states, not 28. Jammu and Kashmir has been shifted. Andhra Pradesh, Assam, Arunachal Pradesh, Bihar, Goa, Gujarat, Jammu and Kashmir, Jharkhand, West Bengal, Karnataka, Kerala, Madhya Pradesh, Maharashtra, Manipur, Meghalaya, Mizoram, Nagaland, then Odisha, then Punjab, Rajasthan, Sikkim, Tamil Nadu, Telangana, Tripura, Uttarakhand, Uttar Pradesh, West Bengal, etc. In these states and the union territories, the federal system works in India. Now, the Parliament has legislative powers and residuary powers also. As I said, there are 3 lists. Union list entirely in the hands of the central government or union parliament. State list entirely in the hands of the state legislature. Third, concurrent list connected to both. The items which are not included in the 3 lists, they are called residuary powers, the remaining powers, the remaining subjects. These remaining subjects also belong to the center in a limited sense. I will come back later how this is distributed. During emergency, the federal system automatically gets converted into a unitary system under Article 352, 356 and 360. If two or more states request the union government, it can make laws on a specific subject convenient for both in the state list. Though the state list is reserved for the state government, at the request of state governments, two or more state governments are combined and the center can make laws. Now, the concurrent list is a common list. It is for both. If a law is made by both on any item in the concurrent list, the central law prevails over the state law to the extent of its contradiction to the central law. This is the working principle regarding concurrent system. State list. Presently, there are 62 items of legislation in state list. State legislature has executive power of legislation on these items under normal circumstances only. That means the subjects of regional importance are put or listed in the state list. For example, maintenance of law and order, justice, jails, police, agriculture, irrigation, public health, local self-government, libraries, pilgrimages. The weather scheme of Environment Department comes under this only because it's a pilgrim item. Fisheries, markets, land revenue, school education. These are all certain subjects which are of local importance or regional importance, entirely and the administrative legislative control of the state governments. These are applicable to all the individuals and the institutions within the state only. Regarding concurrent list, there are presently 52 items in the list. Both the center and state can make laws, as I told you. In case a law is made on any subject in the concurrent list, the central law prevails over the state law to the extent of its contradiction to the central law. Forest, population, family planning, education, including technical and medical education, criminal justice, law and procedure, marriage and divorce. Recently, there is a debate as to what should be the right age of marriage for girls in India. So, marriage and divorce, electricity, press, newspapers, weights and measures, these are all included in the concurrent list. Though, as I said, the items which are not included in these three lists, they are called residuary items. They are given to the central government. Now, let us come to administrative relations between the central and the state governments. Article 256 to 263, a small part of the Constitution, Part 11 of the Constitution deal with the administrative relationships between the central and the state governments. Despite the state list, the center has greater powers on the states in administrative sphere also. During emergency or president's rule, the state is a silent partner. A silent partner. During emergency, there are three types of emergency provided in the Constitution. One is under Article 352, emergency arising out of war, external aggression or armed rebellion, or imminent danger to the sovereignty of the state. In 1962, during Chinese invasion, 1971, Pakistan invasion, 1975, emergency, under Article 352, this power was utilized by the central government. Then the most disputable, debatable, controversial article is Article 356, proclamation of emergency caused by the breakdown of the constitutional machinery in the state. That's what we call president's rule. This has been clamped in the states by now more than 114 times. And the Article 360 relates to financial emergency. But it has not yet been enforced so far, despite the financial balance of the state or country are at stake. Even though we are like that, but emergency is not clamped because it leads to a lot number of consequences. So, under Article 356 in our state of Andhra Pradesh, during 1954 and 1973, governor rule was introduced. All the legislative and executive powers are vested in the president. He governs through the governor when Article 356 is clamped. If the state fails to comply, I repeat, if the state fails to comply with or give effect to any direction given by the center under Article 365, the legislature can be suspended and presidential can be imposed for 6 months. This is a very important thing. Similarly, on Article 356, we all are aware, 9 Congress governments working in the states and assemblies also were dissolved by the Janata government at the center in 1977. Similarly, exactly after 3 months, 9 Janata governments working in the states were dissolved by the Congress government in 1980 by Srimati Indira Gandhi, the then Prime Minister, when she came back to power. So this has become a political instrument, a political threat at the hands of central government to cause fear, to cause a kind of shaking in the state administration when things go wrong between center and the states. And in normal times, how the system works. The center does not interfere in the day-to-day administration of the state. It's a very important point in the context of the present Andhra Pradesh government also. The center does not interfere in the day-to-day administration of the state, including the shifting of state capital. It has been clarified by central government. However, it can interfere by giving directions to the state governments in certain matters. I will try to list them out. Number 1, the state has to ensure compliance with the union laws and implement them in the state faithfully. No breach is acceptable. Number 2, the state laws cannot be an impediment, cannot be an obstruction, cannot be a kind of making inroads into the central laws. And third, to ensure the maintenance of means of communication of military or national importance, thus it is the responsibility of the state to follow the central directions. 4, to ensure the protection of railways within the state. If some galata is going on, if some hooligans test the central properties, the state government cannot close it to keep the legs crossed. It is the responsibility of the state to see that the central government properties are properly maintained and protected, and the expenditure incurred for maintaining central properties will be borne by the central government. Then 5, to devise and execute the schemes for the welfare of the SCs and STs or tribal communities, the state has to ensure the compliance of the instructions given by the center. 6, to secure the provision of the adequate facilities for the instruction in the mother tongue at the primary stage, at least or especially or with reference to the linguistic minorities. Then 7, to ensure the development of Hindi language. And 8, to entrust certain, the center has powers to entrust certain functions to the state government or its officers, and the center meets the additional expenditure for creating these posts or maintaining the system as directed by central government. So state cannot say, no, it's none of my business. It has to accept the central command, the central orders. It can depute staff, it can ask for deputation or something like that. And then center gives directions to the state to implement central laws properly. Last night we have seen one order by Ministry of Home Affairs creating Unlock 4. It has said, it has created a wonderful thing that except in containment areas, the other things are normal. The state government cannot impose containment in the towns or municipalities or local areas against the order of central government. So the center gives direction implicitly. And then 10. The union government may appoint, transfer, or remove the dignitaries like the judges of High Court, members of Public Service Commission, etc. Then the President may, with the consent of the state governments, entrust any work either conditionally or unconditionally to the state government, and that has to be complied with by the state governments. 12. The Parliament can frame rules for the settlement of interstate disputes relating to the use of water and boundaries. 13. The President can constitute an interstate council to settle the disputes between them. 14. Very important item. The All India services. We have 3 All India services. Number 1, Indian Administrative Service, IAS. Number 2, Indian Police Service, IPS. Number 3, Indian Forest Service, IFS. It's not Indian Foreign Service. It's only Indian Forest Service. These services working in the states are governed by the rules, regulations, pay structure, service conditions laid by the central government only. And the state cannot remove them. They cannot create any hindrance in the normal circumstances, shifting them from place. But the state has a right to transfer them from one place to the other or from one post to other post. It can create a post. It can transfer an IAS officer from a higher post to a lower post. It can transfer a person from lower post to higher post subject to service matters and seniority, etc. These are all internal matters of state government. But the central services are always governed by the rules of the central government. Then 15. The center can dispatch, deploy the central armed forces to the states to ensure law and order and to control the civil disturbances prevailing in any part of the state. There is also a bone of contention that some state governments are complaining that don't interfere in our matter because law and order falls in our jurisdiction and you are unnecessarily interfering. Not like that. Maintenance of internal security is also a part and parcel of the responsibility of the central government. Therefore, the central government can deploy its central forces to maintain law and order wherever there is a disturbance or turbulence to the normal prevalence of law and order. And then the center can appoint a joint public service commission to serve 2 or more states at the request of the states in general. And then the central government is empowered to appoint an inquiry committee to inquire into the allegations leveled against chief ministers of the state. This is another important critical area of tension, an irritant between center and the states. The center can appoint an inquiry committee, a special investigation team set to go into the allegations made against the chief minister. The center has that power. And then the parliament may empower the union government to make a grant in aid to any state which is in the need of assistance, such assistance. The central can do that and the state can get that benefit. Then planning commission, it has been renamed as Niti Ayog, National Institute for Transforming India. It is done in January 2014. Prime Minister is the chairman, chief ministers and lieutenant governors of union territories or its members. Similarly, National Development Council, which was created in 1952, then the National Integration Council created in 1961, and the Interstate Council created in 1990. These are all predominantly the pickets of power in the central hand. Now, let us also discuss the tension areas between the central government and the state governments. First one is the mode of appointment of governor. Earlier, there had been a practice that before the appointment of a governor, the center used to consult the state chief minister, sending some 3 or 4 names and requesting him to choose one person. In course of time, it seems that convention was given a farewell. Now it is one of the most critical areas bothering the state governments, that the governors are simply dumped in the states without formal consent of the chief minister also. Then discriminatory role of the governors. The disappointed, the dejected, the refused people at the parliament, at the elections, and they are chosen as the governors. In Andhra Pradesh, we had seen earlier times how Ramal Governor, Ramlal, etc. have done their job in the state. We had also seen the best examples of Dr. Shankar Dayal Sharma, Dr. Krishna Kant, etc., who did a wonderful job. But the way how the governors are working in the states had always become a bone of contention. It had always become a point of discussion, a debate, a dirty dialogue between center and the states. And then another important thing is Article 356 relating to imposition of president's rule in the state in case of the breakdown of the constitutional machinery in any state. This is a very important point. And then deployment of central paramilitary forces in the state to maintain law and order, or in the name of maintaining law and order, and asked for. In fact, the state has to ask for central help, but central itself has deploys its forces to ensure the maintenance of law and order. Then recently, the Niti Ayog has become another point for criticism. Role of Niti Ayog in approving state projects. It's showing bias, it's not fair, something like that. The criticism is leveled. And then role of all India services not helpful to the state government. We had been seeing in different states that some IAS officers are not helping. They are not dancing to the tune of the central state government. Though they are working in the state government, they are not helpful. They are not sincere, and they are playing havoc, something like that. We have seen a number of examples also in many states, where the senior most IAS officers are put to a kind of embarrassment in terms of posting. So this is another important thing. And then the electronic media, TV, it's badly used for political purposes. That was the criticism. The national TV, and then the local channels, how the way how they are playing their role is also causing an area of concern. And the role of Central Vigilance Commission, CBI, are all against working the state chief ministers in many cases. That was another criticism leveled against the central government, an area of irritation between central and the states. And then it had been a long desire and long discussion that the states want more autonomy, more freedom in their respective spheres, and the center is unnecessarily interfering. These are some of the areas where there had been a lot of tension and uneasiness and a lack of harmony between central and state governments. Then, the government has considered all these points at great length and appointed certain commissions to suggest certain ways to see that we maintain a harmonious balance. For example, the first Administrative Reforms Commission was appointed in 1966. Secondly, there was the Rajmannar Committee appointed in 1969. Thirdly, there is Sarkaria Commission appointed in 1983, followed by National Commission on Review of Constitution appointed in 2000, new millennium. And second, Administrative Reforms Commission was appointed in 2005, and Punchi Commission was appointed in 2007. They made a number of recommendations, but how many of them have been put into force is clearly known. Before I conclude, I like to tell you certain comments on the way how the Indian federalism has been working in India. Indian Federation was described as what you call asymmetrical federalism. It appears to be federal, but really not federal. Then some people said it's a cooperative federation. In the normal circumstances, states enjoy their rights, center enjoys its supremacy, its hegemony, what they call. And on the whole, the center and states are working within their limits. So it's called cooperative federation. Then some people call it quasi-federal, half-federal. Okay, neither federal nor unitary. Some people call it a bargaining federalism. The states have become beggars before the center with a begging bowl asking for grants. Neither federal nor unitary, some people say. Some people say collaborative federation. Some people say it's not a federation, it's a quasi-confederacy. Like that, there had been a lot of discussion, debate that Indian federal system is not really genuine, it's not really perfect, like the United States prototype. Thus, there is a clear-cut division and distribution of powers between the central and the state government in respect of legislative and administrative domains. Thank you very much. I am 550. Any questions? Welcome.
Yeah. Any question? Hello.
Dear students, you can put up your questions in the chat box. Yashwini has a question. Can state government make laws?
The state government can make laws only on the subjects included in the state list.
Okay. Sir, I would like to know if the next speaker is online in the meeting. Siva Prasad garu. Hello.
Sir,
Yeah, students, yeah, you can ask your questions.
sir, in this present situation, the role of central government is important or the state government, sir? This COVID-19 situation, the role of central government is important or the state government, sir?
Beg pardon?
Sir?
The question is the role of the central government more important in this COVID situation, or is it the state government?
Okay, public health being a state subject, the state has a greater responsibility to see that these corona or COVID-19 things are largely under the control of the state governments, but the center is also equally responsible to see that the states maintain a kind of uniformity in see that this corona the pandemic cannot spread beyond the reason. So we cannot simply say that the state is only responsible and the center is not. Both have to work in tandem, and public health being very important. That way, the state is more responsible. The center can give directions from time to time as to how this can be eradicated or controlled.
Any more questions, dear students? You can put it up in the chat box, or you can unmute yourself and ask. Sir, Siva Prasad Garu has just joined the session.
Right.
Siva Prasad.
Right. Sir, then you can thank Professor Vijay Raghavachari garu.
Dear students, do you have any more questions? Surya Kumar Rajgaru has a question. Why not central government isn't involved in the state's capital issue?
The central government has made it abundantly clear that it is a state item. We cannot interfere in the matter of the capital. But it's a legal point. Much can be argued on either side. Having already president's order had been issued declaring Amaravati as a state capital, how can the state government can change its capital again? So it's a controversial issue, a legal issue, which is already at the court. We cannot discuss it further. But the central government has already said that it's none of our business to interfere with regard to shifting of the capital, because the state government can shift its capital anywhere within the state.
Yeah.
Right.
Uday
Thank you, sir.
Uday Bhaskar has one question, sir. Is there any checkpoint to check unbiased behavior of the central government?
What is the unbiased behavior of the central government? I would like to know one instance like that.
So what I mean to say is, like, as we all feeling that like the central government is not behaving similarly with all the state governments, is there any checkpoint, or is there any person who can know that, like, is the central government acting equally with all the state governments?
In the present scenario of political situation, I have yet to find an issue where there is a tension between center and except whatever I have explained to you now. Towards the end of my lecture, I said there are certain areas, and mainly the only thing is the GST is a bone of contention. They want GST reimbursement, and the center is also equally affected by the COVID-19 consequences. So normally it does not happen.
Okay. Is the judicial system can have any say in it? Like, if something, for example, in Niti Aayog thing, if some state is getting more preference compared to other state, you can.
That is a point of criticism level like central government, I said already.
Okay. Okay.
Because Niti Aayog is just like a planning commission. They say that the certain states which are very comfortable and convenient to the policies of the center, they are giving more, and those, for example, West Bengal, for example, Kerala, things like that, they are not doing it properly, and there is a bias. The system is already there.
Okay, thank you.
Yashwini has a question, sir. Which government plays an important role, either the state government or the central government?
100%. In India, the federal system is always pro-center. It is centric. We have a lot of centralizing tendencies in our constitution, and the center is always an elderly brother. It's always, it has get its alliance's share. You have to speak about financial relations. They can understand how the devolution of financial powers are done between center and the state. So center is already powerful. It is becoming powerful more in the days to come. Much depends upon the numbers in the parliament, as you know very well. Much depends upon the numbers, the majority in the parliament. So the ruling party is always an edge over the states in regard to these matters.
So thank you, sir. Thank you.
Thank you very much, sir, for joining our session and interacting with our students. We are greatly honored to have you here on this session, sir. Thank you very much. Thank you very much. Now I would like Dr. Padmanabh Rao Garu to introduce the next session speaker.
Yeah. Welcome to Siva Prasad Garu, Honorable Siva Prasad Garu. He is a law graduate and presently at Guntur. He has kindly accepted to be our guest speaker today. He is a lead consultant to AP Commercial Taxes Department of Government of Andhra Pradesh. Presently a member of the GST. Just now, Mr. Raghavachari garu has given a lead to GST. So we are going to discuss about this GST also. He is the member of GST Grievance Redressal Committee of Andhra Pradesh. He is a consultant to Markfed, DSMBA, etc. He is a CA for the last 2 decades, and he is a statutory auditor for the several PSUs. He has a lot of knowledge on GST, and he is an authority on sale tax. He conducted several programs for the departmental officials of the GST, and he is a corporate trainer. We requested him to discuss with the GST and its appliances. Mr. Siva Prasad garu.
Yes, sir. Namaste, sir.
Namaste.
I'm grateful for the opportunity, and so there are around 15 participants who are aspirants of civil services. So very nice to meet you all. And, today we are discussing about the GST. We all know GST is a major reform in the area of indirect taxes. So when I discussed with Padmanabhan sir as to what is the scope of the today's session, so it was given like a basics of GST and the legal concepts behind them, so that we can get hold of the basics, because it is a very vast law, and lot of because taxation issues, fiscal laws are always intricate, because they are directly extraction of money from the public. So therefore there will be a lot of conditions, sub-conditions, and by its very nature the fiscal laws are complicated. So we are not going into the nitty-gritties of the law, but then we are discussing the basic concepts, more particularly cut out for the requirement of the people here. So now we are discussing the basic outline of the GST law. We know the GST law, we are referring it to as an indirect tax. So by its very name, what is indirect tax? There are 2 kinds of taxes. Broadly, taxes can be classified into 2. One is direct taxes and the other one is indirect taxes. So why is it indirect tax? What is indirect about it? There are many indirect taxes, and in the earlier, prior to introduction of GST, there are as many as 20 indirect tax legislations. To name a few, sales tax, service tax, then central excise, then customs, then there are some other state levies like entry tax, what is also called octroi. So all of these are called indirect taxes. Now the GST has subsumed most of the indirect taxes into one unified legislation. So that way, all of these, majority, not all, but majority of the the indirect taxes are subsumed into one, that is the GST law. Now we are discussing about the basic characteristic feature of an indirect tax. So there are 2 aspects to taxation. This is very important for us to understand. There are 2 aspects to taxation. One is levy and the other one is incidence. So levy means upon whom the government is levying the tax and extracting the tax from, who is liable to pay. But then the incidence need not be on the very same person. For example, if I am paying the tax and later I have a right, I have a statutory right to collect the same tax from other person, so the incidence is not on me. The incidence is getting shifted to somebody else. So ultimately, who is bearing the incidence, he is a real payer of the tax. But then he will not go to the government, or the government will not come to him for payment of taxes. The statutory liability is upon me. So in this case, the government is getting taxes from the final consumer, but indirectly through the business person. So the business person is only a gateway or the front-ending interface for collection of taxes, but ultimately the burden is borne by the ultimate consumer. Okay. So this is called indirect tax. Now GST, VAT, service tax, we will go into deeper into them. All of these are under the category of indirect taxes. In contrast to this indirect tax, there is another class of taxes that is a direct tax, and the classic example is income tax, wealth tax. Of course, wealth tax is not there. Gift tax, that is also not there. All of these things, one who is liable to pay is the one who is actually bearing the burden of the tax. So that is, so the levy and the incidence, the burden and the statutory liability to pay, both are on a same person. That is called direct tax. So in direct tax, whoever pays, he cannot pass on the burden to somebody else. Now, we are clear with what is an indirect tax. And in the previous session, I have just joined 5 minutes back. The central and state relations are being discussed. Okay. So any tax, as per the Constitution of India, no tax shall be levied except with the authority of law. So there should be the foundation from the Constitution where the leviability is arising. Okay, so this is called the charging or the leviability, the constitutional validity of the levy. So if we see, we all know under the 7th schedule to Constitution, there are 3 lists. One is a union list, the other one is a state list, and the third one is the concurrent list. So those taxes which are in the union list, only the central government is authorized to levy. Those under the state list, the state governments are empowered to levy. And there are concurrent lists where both the state and the center can exercise a levy. Now, so far, in India, the manner of taxation is some of the indirect taxes are under the heading of central union, and some of them are under the state list, list 1, list 2. So if you take central excise, so central excise is levied by central government, administered by central government. Okay. And then if you take customs, it is also levied by central government. Central excise, except on the excise on liquor, alcohol for human consumption, only that is under the state list. Rest of all are under the union list. So therefore, who has to levy? Who has to levy which tax? That is already recorded, enshrined in the Constitution, and only based on that the leviability or the taxability shall arise. Now, the GST is a jointly administered law. The GST is administered by both the central government as well as the state government. So that is a very Herculean task, and it is a very interesting read for you all. You may go through that in detail. That is one very important area. The way the GST has emerged and the difficulties that are and the negotiations that went through in order to bring the consensus between the center and the state. That is a very interesting, and we all know in our federal structure there is a lot of diversity, and each state's interests are different, divergent. Until now, until the introduction of GST, until the 101 amendment to the Constitution, certain indirect taxes are under the state list, like VAT, entry tax. Okay. Certain indirect taxes are under the union list. For the first time, they were merged and synthesized into one, and a joint levy, a concurrent levy was proposed by the 101, the 101st amendment to Constitution. So with this, what had happened is the GST is a law which will be administered by both the central as well as a state government. So this has required a lot of issues. Okay, and there is another important concept we have to look into when it comes to GST conceptually. There are 2 ways of administration of taxes, more particularly in indirect tax. Two styles. One is production based and the other one is consumption based taxation system, or origin based and destination based taxation system. Let me give an example. If a person in Andhra Pradesh sells goods to a person in Tamil Nadu, so the seller is in Andhra Pradesh, the buyer is in Tamil Nadu. Okay, so on this transaction, the tax is always attached to a transaction, that is called charging section. I'll dwell upon a little later. So let us take sales tax as an example. The sales tax is a levy on the sale of good. So there is a sale of good here, And the sale of good is happening between two people. One is resident of Andhra Pradesh and the other is resident of Tamil Nadu. So which state government shall get the revenue? Whether the Andhra Pradesh state government, because it is from where it is the transaction is originated, where the production is happening, where the initiation of sale is taking place, shall the Andhra Pradesh state government get the revenue? Or the goods are moving physically to Tamil Nadu, the consumption is happening at Tamil Nadu, therefore the state exchequer of Tamil Nadu shall get the tax revenue. Who shall get the tax revenue? Until the introduction of GST, we are under origin-based taxation system. Origin-based taxation system. That means where the transaction has originated, that place, that government, that state used to get the revenues. For example, CST. CST is a Central Sales Tax Act. The Central Sales Tax Act is under the union list. That means it is of a central government, but peculiarly it will be administered by state government, which is under the union list, but the administration will be by the state government. Anyway, the CST revenues used to go to the originating state or the state where the transaction is getting originated. Now, if you let us take the international practice. Okay, there is one common, most famous quotation in the regime of taxes. Taxes cannot be exported. This is very important quote. Taxes cannot be exported. So when we export a commodity, the commodity shall be exported at a base cost. That means without loading the taxes. So in the international tax conventions, almost 100% of the cases, what happens is the goods are exported without any tax. So let us replace our example, that is Andhra Pradesh and Tamil Nadu, for a while with India and some other country, India and Japan. So I am exporting my goods from India to Japan. Now what happens if both Indian government levy the taxes and the Japanese government also levy the taxes? Okay. On the very same transaction, there will be double taxes and thereby the cost of the product will increase. Okay, in order to have a consensus, the international arrangement is the originating state shall not tax, the destination state shall tax. So in this case, the exports are always tax free, except for some protective taxes. See, if the COVID, let us take COVID instance, the export of this VTM, viral that transmission medium, those kits, the export of that is prohibited. Okay, so at times what happens is if the commodity shall be retained in the country, the protective duties will be levied by the governments. So leaving that aside, the normal international trade I am talking about, the importing nation will tax the goods or services. The exporting nation will never tax the goods or services. So the international regime is destination based tax. So whenever the goods or services flow from one place to another place, only the place where the goods are getting consumed or the services are getting consumed shall be the state which is empowered or entitled for the revenue over that. So until this GST is introduced, the Indian style is not in sync with the international practice. Considering each of the states of our country, I mean Andhra Pradesh, Tamil Nadu and all to be independent countries for a while, we are running opposite to the destination based tax. Now GST, as I said, it is a major indirect tax reform for more than one reason. So this is another reason. Another reason is it was now following the principle of destination based tax. So the destination based tax system, under the destination based tax system, what happens is, so if I produce a commodity, that is Andhra Pradesh produces a commodity and it sells to Tamil Nadu, the whole revenue on this transaction shall belong now under the GST only to Tamil Nadu. Okay, but then it is like a paradigm, it is like a U-turn on the way we are accustomed to follow so far. So therefore, many states have objected to this. Many states have objected to this. Mostly the producer states will suffer. One of the most suffering states are Tamil Nadu, Maharashtra. So where the net production is more than the consumption. They produce more, and because of they are producing more, they are used to enjoy more taxes. But then ultimately it is being shifted to consumption based. Wherever the consumption is, that state shall get the revenue. Now, which is a fair way to tax? I'm not going into that. Both are fair. Like if you say left-hand drive car is better or right-hand drive car is better, anything is better, but everybody shall follow one. Only then, otherwise there will be traffic accidents. So both are okay. But then the ecological system of economy has tuned to something. So therefore, the producer states have objected to this. Mostly, I said Tamil Nadu, Maharashtra, Gujarat, some of these states, because their net production is more. They have created production capabilities. They have created the production infrastructure much larger than the consumption that is required for that.
I think there is a problem with sir's connection.
Yeah, freeze ayinattunnadi.
Right.
Let us wait for 2 minutes. Meanwhile, you can make some announcement.
Yeah, yeah. 1 second, let me check sir's connection. Is he joining or maybe a power cut? Sir will join. Yeah.
Yeah.
So dear students, you can quickly, once sir joins, you can quickly ask your questions. Sir is back.
Yeah. There is some technical.
Yes, sir. Yeah, yes, sir.
Some voltage disturbance.
Yeah.
Yeah, okay. Now, how to make good this loss that they have suffered? Okay. So then there was some statistical analysis done, and the average revenues of all the states prior to introduction was captured. Okay, and certain growth in revenues at the rate of 14% is also promised by the central government in order to bring them to consensus, in order to bring all the states to consensus. So there is another levy apart from GST. There is another levy, and that levy is called the compensation cess. This compensation cess was initially thought for a period of 5 years, out of which 3 years is already over because GST was introduced on 1/7/2017, and we have crossed the 3-year mark very recently. So therefore 3 years have gone and 2 more years are left. They may be extending the same. But anyway, what is this compensation cess? On certain commodities, like for example, coal briquettes, cigarettes, aerated drinks like Coca-Cola, Pepsi and all, and certain other commodities, there is a compensation cess. So this compensation cess is collected in addition to the GST and will be collected by the central government. And then the central government will pool up all of these funds and it will distribute it in the name of compensation cess to the respective states where the revenues have fallen short of the earlier tax revenues plus the promised or estimated extrapolated growth. Okay, so this is one of the important leverages or the important negotiations that had made all the states agree onto this levy. Because this GST levy is in a way, I should not use the word compromise, but it had greatly reduced the flexibility of the state governments to have a say on their revenues. Now, if you take VAT Act, some commodities are taxed in some states, some are exempt. Even in the neighboring states, rice if you take, rice is taxed in Tamil Nadu and is exempt in Andhra Pradesh, and we share a border. Okay, so depending upon the state's own interests, depending upon the state's peculiar circumstances and the state's value chain and supply chain systems, so the states used to enjoy the power of levying the taxes as per their own requirements. But then the GST has synthesized everything into the one. It had made the whole nation into one market. So all the taxes shall be proposed only by the GST Council. And the GST Council runs on a democratic system. Now let us see the composition of the GST Council. The GST Council is comprised of the state governments, all the state governments, okay, and the central government. So only with a subject, with certain majority in the GST Council, any law or any recommendation of GST Council be forwarded to the state legislative assemblies or the parliament. Okay, so therefore, each of the state governments had a cut, at least if not a compromise, had a major cut in their flexibility, in their power to levy the tax or not to levy the tax. So depending upon certain local circumstances, the state governments used to exempt certain commodities. Now such a liberty is not there. And many of the state governments have linked their incentivization schemes in the form of taxes. So tax is not a carrot, but it is also a stick, or tax is not only a stick, but also a carrot. So what happens is, at times, let us say if an industry is set up in this corridor, or if an industry is set up with this set of eligibility conditions, then we are not levying sales tax. There used to be a sales tax deferment scheme prior to introduction of GST. So in one word, the scheme is like producing the spinning mills, ginning mills, certain eligible category list is there. In those categories, what happens is the sales tax what they used to pay need not be paid for a period of 5 years or 10 years. There are certain schemes under that. So whatever is not paid in the first year shall be paid in the 6th year, and whatever is not paid in the 2nd year shall be paid in the 7th year. Whatever is not paid in the 5th year shall be paid in the 10th year. So this is called sales tax deferment scheme. That is there in AP only or in some other states. Now all of these liberties are not there. All of these liberties is not there, because now we are into one nation, one market. One commodity shall have a same rate of tax across the country. So how all the states were brought onto one pedestal, onto one common platform, onto the speaking terms. So there, I shall elaborate a bit on how the GST is administered. Now, the GST is administered in this particular fashion. One, all the transactions are categorized into intra-state, that means within a state, and interstate, that means between the states, one state to the another state. So in case it is an intra-state transaction, so what is an intrastate and what is an interstate? It is a very technical subject, and there are a lot of exceptions, counter exceptions, all of those things are there. Leaving it aside at a very bird's eye view, at a conceptual level, whatever that happens within a state is called intrastate. So if something happens within a state, that is intrastate, the GST will be collected in two parts, two equal parts as of now, two equal parts. They are called SGST and CGST. So the CGST portion is the central GST portion, and the SGST portion is the state GST portion. Let us say this commodity, the rate of tax is 12%. The rate of tax is 12%. So 6% will be collected in the name of CGST, and 6% will be collected in the form of SGST. So the CGST will go to the central government, and the SGST will go to the state government. And again, the CGST, whatever had gone to central government, that will be devolved onto the states, because that becomes a central revenue. States will have an indirect share over that, as per what the previous session you were all discussing. So the central, out of the CGST, again the states will have a share. That is all I am not discussing. But then the basic levy is in two parts, the CGST part and the SGST part. And both of these levies are administered by single authority. So how to do the single authority? Whether the GST shall be administered by state government or the GST shall be administered by the central government. Who is an administrative authority? So that is also a very big issue. This was a very big issue, and it is an issue even today. Okay, so what happened is the central government's tax base used to comprise of very little number but very high value. If you take central excise earlier, now I am talking about how they are the interplay of joint administration I am discussing. So earlier, under the central, before introduction of GST, the central excise, the customs, the taxes that were main indirect taxes that are administered by central government, there used to be very little number but the collection used to be, the value used to be very high. And if it comes to the state levies, that is VAT, the threshold is very low. It has almost started from 2.5 lakh, whereas the central excise, the threshold used to be 1.5 crore. So the basic exemption limit under the state levies are very little, very small. So there used to be a huge tax base. Now there is a common tax base. Every individual taxpayer, every business person, whether it's a manufacturer or a trader or a service person, everybody is the same. There is a single threshold, that is 20 lakhs under the GST. So whoever had a turnover exceeding 20 lakhs, he falls under the GST ambit. Now then, how to distribute this tax base? So that was also a very major debate. That is why I said the way the GST is introduced in India itself is an epic. It's a very big story. But then through that story, we can know a lot of administrative principles. Okay, so that is why I'm just touching upon the main important aspects of the story. So then how they decided is, in order to have an almost like tax neutrality, that is about the revenue neutrality, here also the tax base neutrality. That means because how much of tax base is there, so much of administrative machinery was built. Now all of a sudden we can't have huge tax base to central, which is not having that much of a tax administrative structure. The tax administrative structure of center is very small in its number and size. Whereas a state, if you see, there are almost 140 circle offices in Andhra Pradesh, in a single state. That is of a divided state. So therefore, the tax administrative machinery of state is huge. So they decided like this. In the tax base with turnover less than 1.5 crore per annum, 90% of the taxpayers are allotted to state governments and 10% are allotted to central government. Normally, if you see, the turnover limit of 1.5 crore is a very big limit because many small players are there. Almost 80 to 85% of the taxpayers have a turnover limit of less than 1.5 crore. So out of that, that is up to 1.5 crore limit, 90% of the tax base, that is the taxpayers, were allotted to the state governments for administration. It is a very peculiar administration. If a taxpayer falls under state jurisdiction, both the CGST Act and SGST Act will be administered by the state officer alone. So it is not like state officer will implement SGST Act, central officer will implement CGST Act. No, it is not like that. It is like if my file is under the state jurisdiction, all the GST law, that means the CGST Act, the SGST Act, the IGST Act, the Compensation Cess Act. So there are 4 important legislations under the GST. All of these 4 will be implemented by my jurisdictional officer. So my jurisdictional officer could be a state officer or a central officer. So that goes as per the allotment. Now, for the taxpayers whose turnover is above 1.5 crore, 50% are allotted to center and 50% are allotted to state. Now, whether this allotment is a permanent allotment, no, they agreed that after 3 years, it will be shifted and they will be swapped from the central authority to the state authority. Okay. Then again, lot of issues are there. Like there are certain important taxpayers, like state PSUs are all there. The state governments are not okay to let their control go away on those important taxpayers, every state government. Okay. And then there are a lot of enforcement issues. What is an enforcement issue? I tell, if there is an errant taxpayer, see, whoever is administering, whether state government is administering or central government is administering, they are administering both the Central Tax Act and the State Tax Act. So therefore, if an assessment is done improperly, revenues of both the central government and the state government are affected. Now, if there is an errant taxpayer, can the enforcement be common? Can the central officer catch hold of a person who is under the state officer's jurisdiction? So all of these issues have come up. So then they said, once the jurisdiction is identified for assessment purpose, that means to bringing him to book, only that particular jurisdictional officer had got the right. But then when it comes to enforcement, when it comes to inspection, when it comes to what you call the site visit, there are two aspects of tax administration. One is the vigilance portion, the other one is an assessment portion. So the vigilance portion is like having a surveillance on the taxpayer. Who is doing what, where the commodities are moving from, or if you take the online OIDAR, online information data access and retrieval services, the data traffic, from which IP to which IP it is flowing, all of these things, the enforcement can be exercised by all the officers. That means the vigilance can be by both the officers. So now, one vigilance officer of center had chased a taxpayer, caught hold of them. So there is a reasonable belief that there is a tax evasion. But then he is falling under the state jurisdiction. Now, can he do the assessment? So the answer is like this. He can definitely have a vigilance oversight on the person, but then the assessment shall be handed over to the respective. Okay, so somehow with lot of discussion and give and take, they have come to a consensus like this. Up to 1.5 crore, 90% tax base with states, 10% tax base with center. Above 1.5 crore, 50-50, and that is also a temporary or a temporal arrangement. After a certain point of time, that is 3 years that was agreed, there will be a shift in the this one, and the allotment is by some lottery kind of a system. And in particular select cases, the state and central had by mutual negotiation, there is an information that they have swapped this taxpayer base as well. And when it comes to assessment, it shall be with the allotment only to whomever a taxpayer is allotted. But then when it comes to enforcement, vigilance part of that, all the officers can enforce their vigilance over all the taxpayers in that territorial jurisdiction. So this is how they have come to certain consensus. And then the next part is, every state government has insisted on certain leverage for them. Okay. So by and large, we are okay to have one rate of tax for one commodity. It is not like all the commodities have one rate of tax. We have got majorly 4 rates of tax under the GST Act. That is 5%, 12%, 18% and 28%. By the constitution, by the way the act is drafted, the maximum GST that can be levied is 20% under CGST and 20% under SGST. That means put together it cannot exceed 40%. So beyond 40%, that means under 20% under each of those heads, the act is not empowered to levy beyond 20. But anyway, the highest rate under the GST is 28%. So let me discuss a bit on the rates of tax now. The next aspect I wish to take up. Okay. So there are broadly 4 rates. Why I said broadly is the way it started is by 4 rates, but now it is almost like I'm not very sure about the count. We had almost increased it to 12 to 13 rates of tax now. Okay. It is not that one commodity will have, or all the commodities will have one rate of tax. It is not like that. One nation, one rate of tax does not mean all the commodities to have one rate of tax. It is not possible. There are certain European countries where it is happening like that, like at an average level. But for a country of our size and for our diversity and for our diversity between rich and poor and for our diversity between state and state, it is not possible nor desirable also at my personal level I am saying. So therefore, our country, we have chosen 4 rates of tax. And the rates of taxes were chosen keeping under the view the concept of revenue neutrality, R&R. This revenue neutrality, R&R concept was implemented. So what is this revenue neutrality? I said in the introduction, prior to GST, there are multiple indirect taxes that are being levied on a single commodity. Like if you take one commodity, at the time of import, it was subjected to customs. And when it was manufactured, it was subjected to central excise. And when it was sold from wholesaler to distributor, it was subjected to sales tax. And when it had entered a state, it had suffered entry tax. And when certain services are rendered, it was subjected to service tax. and finally when it was sold to the customer, it was subjected to sales tax. So on a very same commodity, when it has crossed its value chain or supply chain, it was subjected to multiple rates of tax at multiple bases. Not that every tax is on the same base. Like if you say central excise, the average rate is around 12%, but it is on only 60% of the MRP. Because the central excise is a tax that was levied at the instance of manufacture. At the instance of manufacture, normally the commodity's valuation is not at accrued. When it passes through the supply chain, it gets the valuation. So therefore, the rate of tax used to be on multiple bases and it was levied throughout the chain. So a major exercise was carried out at the time of implementation of GST, and that exercise is RNR, revenue neutrality. So if you take a commodity, what is the average tax in aggregate that is levied, that is being levied on a commodity at a national average? Again I said the rates of tax are differing from state to state as well. So the weighted average rate of tax that every commodity had suffered at all the instances, that was aggregated, and broadly they are classified into 4 buckets. And if that average rate of tax is around 4.5, let us say, or 5.5, 5% is fixed as a rate of tax for that commodity or service. Okay, so this revenue neutrality is a very important factor. So if I further elaborate on that, let us say one commodity had suffered 12% as central excise, 5% as VAT, 15% as service tax. So the nominal addition is like 12 plus 15 plus 5. So that is 15 plus 5, 20 plus 12. That is 32. But then 32 is not on 100% all the time. If you take service, though the service is 15%, it is only on the service component, which may be a little bit lesser than the 100%. So therefore, if you take the average on the whole at the base of the commodity, let us say it is coming under 12%, near 12%. So 12% was fixed as a GST rate. So in all, the GST rates are so introduced, that each commodity level, there shall be no incidents, there shall be no further incidents just because of the way the administration of these taxes has changed. In most of the cases, the bite was chewed by the government only, not by the taxpayer. Okay, and then there was another important concept that was introduced. Yes, sir. There was another important concept that was introduced, that is anti-profiteering. What is this concept? It is very important concept, and it was also very influential concepts of introduction of GST. Anti-profiteering is no businessman can profit himself unduly out of the changes in the rate of tax. So if by combination of all of these into GST, there is a lower incidence of tax, this incidence shall be passed on to the customer, but shall not be enjoyed by the taxpayer, but shall not be enjoyed by the business house. So similarly, what was not eligible as input tax credit under the earlier regime was now made eligible. Okay, so this input tax credit, there is a seamless availability of input tax credit. I will explain that also, because without that I cannot close this very important concept. So any incremental advantage that was given because of the GST shall be passed on to the final customer, but there shall not be any undue enrichment of the same by the business person, by the intermediary. So this is called anti-profiteering, and to administer this anti-profiteering, one national anti-profiteering authority was constituted, and they are empowered to levy a case on any business house if it was caught that they have not passed on the advantage. Okay. Now I have discussed about the rates, the state and central joint administration and all. The last one, the last topic I am introducing is the input tax credit. Okay. What is this input tax credit? Now I just said the indirect tax is a tax that is levied, that is the incidence is on the customer, but then it will be levied from the business house. Then it is sufficient if there is a tax on the last step. If at a retail outlet there is a tax, because at the retail outlet is a place where the customer is getting into interaction for the first time and the last time. So what is the point of having a tax at all the steps? It is to have a monitoring mechanism. So because of this, what happens is no part of the economic activity shall be outside the purview of the government. So therefore, they shall levy a tax at every step. So it's like this. Let us say we are traveling by a train. Okay, we have started from our place, my place, Guntur, and I am going to Delhi. I can very well pay a single ticket. I can purchase a ticket from Guntur to Delhi, but GST is not like that. For at every place, I have to pay my incremental tax. That is called the value addition tax. So at every junction point, at every tax authority, at every change in the value chain, so from wholesaler to retailer, they have to pay the tax. From retailer to another sub-retailer, they have to pay the tax. Does not mean they are paying the tax on the full value again and again and again. They are paying the tax only on the value addition. So let us say 100 rupee commodity is there. At the time of sale, the purchase value is 100, and it was being manufactured and sold for 150. So 50 rupees is a value addition in the hands of the business house. So it is sufficient if they pay the tax on the 50. 100 they are already paid at the time of purchase. 50 they are now paying. So if you see, at any point of time, the government is rest assured of the revenue to the extent of the economic activity carried on. So it is not that, though it is an indirect tax, the government is not waiting for the last transaction to happen, the last interaction with the customer to happen. Rather, the government is collecting the taxes at every stage for the incremental economic activity, the incremental value that was added to the commodity. Okay. Then how it is administered, how to calculate the incremental advantage, it is very difficult. So the governments, not only in India, it is across it's world practice across the international practice it is. So what they do is they levy the tax on the full output value. That means they levy the tax on 150 fully, but then whatever taxes that are paid on 100 will be given back. So it is a way of recovering tax only on 50, because 100 had already suffered tax. Now, because of my intervention, because of my production or service or something, the value of this commodity had gone up to 150. So it is not that I pay the tax on 50. Rather, the act is like I have to pay my tax on 150 fully. Then whatever the taxes that are paid up to the previous leg, up to the previous limb, that will be given back. So this giving back is called input tax credit. So this way, the tax is always paid on the incremental portions only. Now let us say this 150 was sold for 200 in the next chain. So he did some sort of secondary repacking or something like that, some labeling, some value addition he did. The value grew to 200. So what happens? He has to pay tax on 50. The way is, he will pay the tax on full 200 again, but then whatever is paid on 150, upon showing the receipt or certain proofs or certain portal data and all, it will be given as a credit. So this manner is called input tax credit, and this is the one which has ensured the tax is levied not again on the base value. So there is no cascading effect. That means tax on tax is eliminated because of the concept of input tax credit. Now until GST, we are following the silo approach. That means VAT is one tax, service tax is one tax. Though there is no tax on tax under VAT, though there is no tax on tax under service tax, if you look at the major picture, there is a service tax on VAT and there is a VAT on the service tax. So indirectly there is a cascading because there is a silo approach. Each tax is administered as an individual entity on its own. Now all of them were put through, all of them were made into one. So no difference was made between the goods or services. So that is why the name Goods and Services Tax Act. No difference was made between the activity, that is manufacture, trading or service, all are bought at par. No differentiation as to the state. That means every state are all one and have moved from the consumer originating to the consumer based tax system. So that way, almost like every aspect of tax administration, collection, leviability, constitutionality have undergone a change. That is a reason why it is, even after 3 years, it is yet to stabilize. And the major portion is 100% it was administered through portal. So that is another major challenge that had been a reason for the delayed stabilization of the act. It is yet to stabilize because no manual intervention, because it is being administered across the states. They have adopted one GSTN, that is GSTN portal, one online portal. So every transaction, every reporting is being done through that portal. So I have not gone deeper into the things. I have touched upon the basics. Okay, but then it is a very interesting read. Even from the constitutionality, how the federal structure, without compromising on the federal structure, how this law was introduced in a mosaic like our country is a very interesting thing. So I thank Padmanabhan sir for giving me this opportunity to interact with the future IAS officers of the country.
Yeah.
Thank
We
you,
will
sir.
have question answers.
Yes, sir. Yes, welcome.
Yeah.
We'll take any questions.
Director Madam.
Yes, sir. Yes, sir. Yashwini has a question. The concept of GST, when did it originate? When did it originate?
Yeah, I can't give the exact reference point to that, madam. But then it has originated quite a long back. It is an international phenomena. It is not under India alone. There are more than 150 countries, 150 countries that were already implementing this concept of GST. In India, it has almost originated from 1990, that is 2000. We have got a concept paper and we are working on them since 2000. And then it had took almost 10 to 15 years for the concepts to stabilize and then to arrive at a consensus. For exact, because I know I had a little interaction with a few of my IAS aspirants, friends, and those who qualified also. You require more specific data. I couldn't give the exact reference point, madam.
Any other questions, dear students? You can unmute yourself and ask questions.
Devaki, Padma, Lalita.
So I never thought an interaction on GST would be
Yes, sir.
much engaging and enthusiastic. Yes, sir. Thank you.
Any more questions? Hello? So then thank you, sir.
Yes, sir.
Thank you very much, sir.
Intentionally spent more time on outline and the background because it will be more pertinent to you, to the IAS aspirants. So
We will have a second session, sir, whenever you are free during the next month, and we can go in depth.
Yeah, we can go into the exact technical concepts like what is reverse charge, what is forward charge, what is lateral charge. All of those concepts are there. That is inside the GST Act.
Meanwhile, we will go through the earlier question papers and those questions which have appeared, we will give it to you, sir, so that you can explain them. Yeah.
I'll know then what is the...
Yeah, Devaki has some question.
No, she only told that this interaction was very good and enthusiastic and engaging. Surya Kumar Rajgaru has one question that why not fuel come under GST?
Yeah, then it is like most of the states are not agreeing to that because if states agree, the major portion of the state revenues are from fuel. See, there are few subject matters like one is fuel and the second one is alcoholic liquor. So these two, the state government's revenue is very high on these two aspects. Okay, so many of the states have agreed to GST subject to the condition that the alcoholic liquor will be reserved to the states because they want their full power to levy their taxes on alcohol. And then by and large, they have agreed to bringing the fuel, that is 5 aspects: petrol, diesel, aviation turbine, crude, and then another one is also there. So these 5 commodities, these 5 basic fuel products, they have agreed to GST, but not now, at a later point of time when they sit again. Okay, but then if that was brought in, that will greatly reduce the net impact of the taxes on the customers. Okay, because they will also get into the value chain. There will be a progressive input tax credit settlement system on that. It will greatly reduce the rate of the taxes and it will bring down the inflation a bit. But then there will be a lot of cut in the state exchequers, respective state exchequers. So therefore, they are not yet ready for that. That is the reason they have intentionally, or rather in the negotiation, it is their point that these two commodities shall be to the exclusive authority of the states.
Yeah. Yashwini has one more question. Which tax is imposed by the central government, but the state government collects it?
It is not now, madam. It is under the past. It is in the past. It is CST, Central Sales Tax Act. CST, not GC, Central.
So that's all about the questions, sir. Thank you very much for giving us, enlightening our students with
Thanks
all
a
the
lot,
important.
madam. It's a good opportunity.
Yeah,
Thank you.
yeah, definitely.
I really,
Thank you very much.
thanks. Namaste.
Thank you.
Madam, you make announcement. Thank
Yes,
you.
sir.
Thank you.
Yes.
Yeah.
Yes, sir.
Please.
Dear students, this week's assignment we have for seniors need to write an essay in 1,000 words on flora and fauna of India. Seniors will be writing an essay on flora and fauna of India in 1,000 words, whereas juniors will write an essay in 500 words on rivers of Andhra Pradesh and Telangana. I repeat, juniors will write the essay on rivers of Andhra Pradesh and Telangana. Please submit it before Friday. So I hope we'll end the session, sir.
Yes, yes, please.
Yeah. Thank you very much, students.
Bye. Bye.